I'm a DV1 visa holder and I came in America in March of 2019. When can I go ahead and file for my wife and sons to join me from Cameroon?
The next day after you got here with a green card.
Should I use my married name to fill up the forms? I want his last name on my documents.
Should use his married name? You don't want. He does not want the list.
Should I use my? She does.
Yes, use your married name.
Is it okay?
Absolutely.
Abby said, I'm 22 years old and my resident mom filed for me a week before I turned 21. A month after I turned 21, she became a citizen. The I-130 was approved. What's my category, and can I still be considered a daughter of a resident and apply for a pardon here and get a visa since that category is actually current?
She's over 21 now?
She's 22, yep.
Nope, you're F1 category.
Even if they applied like one?
Yeah.
Oh,
yeah.
Damn.
Yeah, you don't get child status protection after that.
Thanks. All right, Sean Lewis saying, hey, Brad, my grandmother filed an I-130 for my mom in April 2013, and it was approved in August 2014. I was 19 at the time. However, I'm going to be 25 in October. Will I be able to get a green card with my mom, or should I look for another option?
You can certainly do it. It'll be about another year to go. You're in the F2B category, and you would have to do a provisional waiver, go home and come back, unless by luck of chance you're 245I, which you never know until you come see me.
Alea said, if someone who had an asylum case pending and had food stamps for the last year, for less than a year, if that person applies for an adjustment of status in November, could that affect their application?
No.
It will not affect it?
No.
Amazing.
All right, our next one comes from Fabian Ernest saying...
Because there's no affidavit support requirements for an asylum adjustment.
Ah, okay.
All right, our next one comes from Fabian saying, I'm following my AOS since January 2018. I got my interview in July 2018, and I never received a response. When I called, they told me my case is administratively closed. I don't know if it's because of my asylum case that's pending, and he's also got his I-130 approved.
Yes, it's because your asylum case is pending. You have to withdraw the asylum case in order for you to continue with an adjustment.
We've got kind of a long one from Michelle, so bear with me, Brad. So basically, Michelle was born in the UK and she's been residing in the US as a permanent resident for the last 16 years. In that time, she's gotten married and divorced twice and has kids from both marriages, and has taken government assistance programs such as daycare, food, and Medicaid because she was a single mother of two and she needed help. Now she's wondering, because of the new public charge rules, how is this going to affect her given that she's taken support for her and her children? And
she doesn't have a green card yet?
She has her green card, but she does not have her citizenship.
Okay, so let me explain public charge.
Okay.
This is only for people who are applying for a green card. If you already have a green card and it's from 19 years ago, none of this should be affecting you. And by the way, there's no public law change, meaning that the law hasn't changed. The way Trump is going to interpret the law has changed. What previously the regulation is that in order for you not to be a public charge, meaning that in order for you to prove that your relative will not go on government assistance, you have to show that you earn 125% above the poverty level. That's what needed to be shown. Now, Donald Trump changed his interpretation of what a public charge is. Now his interpretation is that and by the way, this takes effect October 15th. So if you have an adjustment application filed before October 15th, the old laws will apply. The new laws will apply after October 15th. And what the new law will say is that if you earn less than $62,000 a year, whether you have to just take care of one person or 10 people, there is a presumption now when you file for your relative that your relative will take government assistance. And now it is for you to prove to the government that they will not. So they say, for example, if you're going to earn less than $62,000 a year, your relative better be showing up with some medical insurance. Okay, that's one way to prove it. So there's going to be things that have to be done. The presumption is it's not just show a tax return. If your tax return's under $62,000, you now have to prove to the government. It's not enough to say, hey, my petitioner earned $62,000, my $50,000 a year. you have to prove to the government that you're not going to become a public charge. And they're going to list ways in which to do it. It's going to be a lot easier for you if you file before October 15th. I believe there's going to be a lawsuit, and there's going to be an injunction, and this rule is not going to go into effect, or if it goes into effect, it'll go into effect for a very short period of time. You should not be scared to file for your relative. We took a call from that gentleman from Indonesia. He's like, I'm a U.S. citizen. Should I file for my mother? And I said, yes. And he goes, well, will the old law apply or the new law? Well, if you're out of the country, the new law is going to apply if it goes into effect, because you're not going to be submitting an affidavit of support for at least a year from now. So unless you're submitting an affidavit of support before October 15th, the old law is going to take effect. After October 15th, the new law. So when you file an adjustment, you're submitting an affidavit of support with it. The old law will take effect. But that doesn't mean you shouldn't file, because who knows what the law will be in a year from now. File, figure it out.
Somebody's kind of follow up with that. First Lady said, what happens if a person is not able to file before that date?
Then you can't. I mean, the world's going to turn, and October 15th is going to come here, and not every human being in the United States is going to get to be filed for before October 15th. We're going to have to deal with it. See how the rule's interpreted. Fight it out. Gotta take it as it comes.
AKA, don't do this without an attorney, folks.
That was
are
the
you
next
doing?
thing I was gonna say.
Right.
Don't do it by yourself.
No, my God. But the attorney is like, we don't even know how they're going to interpret this. How are you going to know how they're going to interpret
Right.
your application?
Right,
Don't
we'll
do
have
it,
to see.
family.
Yeah.
Don't do it. Yeah, don't do it.
All right, Transcending saying, can I use the issue date on my driver's license to prove I've served the 10-year bar even if the license is expired? Would the consulate official mind that it's expired?
I don't know. There's lots of ways to prove, you have a 10-year bar. Most that you've overcome it, meaning that you've been in your country. Most likely would be that there's no record that you entered the United States, and there's a record that you left more than 10 years ago. But you can bring pay stubs, you can bring lots of things to prove even 10 years.
Our next question comes from Halle Berry, who said, I came in with a B1, B2 visa from Nigeria in 2017, and I married a U.S. citizen. I did my interview for my green card in March of this year, and I haven't heard back from USCIS. Should I be worried? I've renewed my work authorization last month.
I don't know about worried, but I would certainly be a bit concerned that it's been now more than 120 days and you haven't heard anything. You should come see a lawyer.
GT saying EB3 India filed employment base 485 from Baltimore. The latest status as of July 30th, 2019 says the case is ready to be scheduled for an interview. Now, what does this mean and how long to get an interview?
It just means that they've looked at your application and there's nothing else that you need to do. When you'll get an interview beats me. But it doesn't mean it's ready to be an interview means you're going to get it tomorrow. Just means they've looked at your application. They actually use the wrong language because it confuses everybody. What they should say is, we reviewed your application, everything is all set. You'll hear from us when you want to hear from us. That's basically what it means.
Right.
But I don't know what day you're going to get an interview.
Our next question, I was smiling at First Lady Hewitt, who said, I'm not actually worried. Spartan Bernstein's got my back.
All right.
There you go.
I like that. Peace Ann said, can I file for Social Security and get my driver's license on a B1, B2 visa?
No.
Hey Brad, I'm a permanent resident. My 9-year-old son got his visitor's visa, will be visiting for the holiday. How can I go about letting him stay here and go to school and not return? Who's this, the nephew? No, his 9-year-old son.
And what's his status here?
So Shane is a permanent resident. The 9-year-old son got a visitor's visa.
Okay, great.
During the holidays. So how can he get him to stay here? No, he's going to come during the holidays.
Which holiday are we talking about? Christmas?
Possibly.
Or his next holiday.
When the son comes here, first of all, he can't come with the intention of getting a green card. Okay. So if that's what your intention is, he's already violating the law. But he's coming here with the intention of visiting.
Right.
After he's here, if you change your mind and want him to stay, come see me. We'll figure out where the law is in 6 months from now.
So a permanent resident can somehow get their
we'll
son
figure it
there.
out.
Okay.
How long does it take after USCIS receives the answer to an RFE to make a decision?
It's supposed to take up to 120 days, but sometimes they take years. After 120 days, they should be giving you a decision.
All right, Danielle Sita saying, hey, my asylum has been pending for more than 5 years, no interview. What should I do?
Come see me. You need to file a mandamus if you have a serious asylum claim.
Yeah, 5
And our
years.
last question of the moment comes from No Corruptos, No Impunidad. Says, I applied for VAWA in July of this year. I got divorced. New fingerprints were done in August, and a new work permit has been issued. The previous I-130 was stopped. Can I continue working with my previous work permit, and how long would it take to get a new one under the VAWA?
You can work with your social security number. Your work permit's not valid anymore. The taxes will go through. You file a VAWA, you'll get a new work permit. The fact that you worked out of status won't prevent you from getting a new work permit on the VAWA, and it won't prevent you from getting a green card on the VAWA.
So keep working.
So keep working, basically. Thanks for watching. For more Brad Show Live, like and subscribe to our YouTube channel.